3 slides. 3 slides is all it took for Israel to attempt to rewrite international law as we know it. They killed a man. They then released 3 slides justifying what they did. They claimed that he was a military commander. They claimed that they took precautions. They claimed that it was all done in self-defense. And it sounds almost plausible until you actually read the law that they're referring to, and it makes you think, are these claims meaningful? Let's have a look. In the first slide, they claim that their strikes are in accordance with international law and that precautions were taken to minimize harm to civilians. Now, here is the thing. Precautions don't mean anything if the strikes themselves aren't in accordance with international law. Article 2, Section 4 of the UN Charter clearly states that all member states are to refrain from the threat or use of force against the territorial integrity or political independence of any member state. And a military strike on Iranian soil to kill Iran's supreme leader would be a prima facie violation of this very sovereign principle. Article 2, Section 1 of the UN Charter literally states that the United Nations as an organization is based on the principle of the sovereign equality of all of its members. And you might argue that Article 51 of the UN Charter enables nation states to have or make use of their right to self-defense if an armed attack occurs against them. But here's the thing. That requires an actual armed attack to occur against them in order to invoke that article. But there is no armed attack occurring against Israel when Israel is assassinating the supreme leader of Iran. Now, before we proceed, there is 3 terms that I need all of us to be familiar with that I'll be using in the rest of this video. The first one being jus in bellum. Jus in bellum are regulations in international law that determine the do's and don'ts when inside of an armed conflict, like precautions, precisions, whom to not attack, all those things. The second term is jus ad bellum. Jus ad bellum talks about whether or not the use of force or a conflict is legal or not, is it justified or not. The third one being what we call jus contra bellum. Jus contra bellum talks about the reasons why the use of force is prohibited. So you could say that before going to war, we would first check jus contra bellum. If our reasons to go into war meet the exclusionary principles present within jus contra bellum, we will then check with jus ad bellum. If jus ad bellum also affirms the use of force, only in that scenario we will actually utilize force, and that force being utilized would be in accordance with jus in bellum. Anyway, now with regard to Israel's assassination of Iran's supreme leader, even if their strikes are in accordance with jus in bello, that doesn't cure a violation of jus ad bellum or jus contra bellum. And this needs to be understood. The rules of engagement don't matter if the engagement in itself is a violation of rules. International Red Cross clearly states that the justification for jus in bello doesn't prevent the application of jus contra bellum. And the IDF just ignores this, and they still claim to be international law compliant. In the second slide, they claim that Khameni was a lawful military target as the commander-in-chief of directing proxies. Now, according to jus in bello, more specifically the first additional protocol to the Geneva Convention, civilians are protected from attacks unless they take a direct part in hostilities. What that means is that status is not determined by title, it is determined by function. And the ICRC clarifies this. They clearly state that civilians are all persons who are neither member of the armed forces of a party to the conflict nor participants in levy en masse. And what that means is that heads of state are not automatically members of the armed forces. A political and, in case of Iran, a religious leader who is not formally integrated into the armed forces with a continuous combat function, or someone who does not have formal integration in the form of a permanent unit that is distinguishable by uniform, remains to be a civilian. What that means is that Ali Khamenei had full civilian protection under international law when he was assassinated. Plus, the 1973 Convention on the Prevention and Punishment of Crimes Against Internationally Protected Persons literally states in the first article that heads of states are internationally protected persons, and within Article 2 it is clearly stated that any sort of murder or attack to an internationally protected person is criminal. And mind you, all of this comes under jus in bello. That is, all of this comes under the assumption that this attack was legal to begin with. All of this comes under the assumption that this strike comes under valid rules of engagement. But again, the engagement in itself is not in accordance with international law. Anyway, in the third slide, they call it to be a precise elimination of the highest military authority responsible for directing attacks. Now, precisions and precautions are jus in bello requirements under the 1977 first additional protocol to the Geneva Conventions. However, this isn't an armed conflict to begin with, so the laws that they're referring to being compliant with are of no meaning, as there is no armed conflict governing laws to adhere to. Be that as it may, directing attacks is not the same as direct participation. Mind you, direct participation is what is considered to be a reasonable line of reasoning to be able to attack or kill a combatant. Anyway, so the point is, the IDF claims their attacks are legal under a legal framework that doesn't even apply to what they're doing. And if anything, decategorizing Ali Khamenei into a combatant is ironically a violation of international law. And with that said, it is strongly assertable that the assassination of Ali Khamenei by the state of Israel is in fact not consistent with international law, that is, in contrast to their claims of being in accordance with international law. Thank you.